Good day everyone. So we'll be discussing about Chapter 4, Extinguishment of Obligations, Subsection 3, Tender of Payment and Consignation. So Article 1256 states that if the creditor to whom tender of payment has been made refuses without just cause to accept it, the debtor shall be released from responsibility by the consignation of the thing or sum due. So it means that tender of payment without consignation does not extinguish debt or obligation. Consignation must follow ana. Mobitaw nga ang tender of payment and consignation dapat mag-uba na sila duha. Consignation alone shall produce the same effect in the following cases. So, number 1, when the creditor is absent or unknown or does not appear at the place of payment. So, ingani nga case, if wala si creditor or wala siya nagpakita, so there is no tender of payment. Number 2, when he is incapacitated to receive the payment at the time it is due. So note that this is through only or applicable if there is no legal representatives si incapacitated creditor nga pwede mo dawat sa tender of payment. Number 3, when without just cause he refuses to give a receipt if dili muhatag og resibo. So pwedeng i-consign na lang ni debtor sa court ang iyahang payment. Number 4, when 2 or more persons claim the same right to collect. If daghan ang mo claim, so let them settle their claims in court. Number 5, when the title of the obligation has been lost. So sa ingani nga case, if the written document is lost or misplaced, so much better nga isettle ni sa court. Okay, so what is tender of payment? So it is the definitive act of offering the creditor what is due him or her together with the demand that the creditor accept the same. So, when a creditor refuses the debtor's tender of payment, the law always allows the consignation of the thing or the sum due. So, ang tender of payment, mauna siya ang act on the part of the debtor of offering to the creditor the thing or amount due. So, kibali mauna siya ang preparatory act for consignation. Well settled is the rule that tender of payment must be accompanied by the consignation in order that the effects of payment may be produced. Okay, so consignation. It is the act of depositing the thing due with the court or judicial authorities whenever the creditor cannot accept or refuses to accept payment, and it generally requires a prior tender of payment. So consignation is somewhat the option to consign with the proper authority. Of course, this is done after complying with the formalities required by the law. Tender is the antecedent of consignation. That is an act preparatory to the consignation, which is the principle and from which are derived the immediate consequences which the debtor desires or seeks to obtain. Tender of payment may be extrajudicial, while consignation is necessarily judicial, and the priority of the first is the attempt to make a private settlement before proceeding to the solemnities of consignation. So, note that tender of payment must be number 1 in legal tender. Number 2, include interest. And number 3 is unconditional. Tender and consignation, where validly made, produces the effect of payment and extinguishes the obligation. It is of no moment if the refusal to accept payment be reasonable or not. Indeed, consignation is the remedy for an unjust refusal to accept payment. Requisites of consignation. Moreover, in order that consignation may be effective, the debtor must show that number 1, there is a debt due. Number 2, the consignation of the obligation had been made because the creditor to whom tender of payment was made refused to accept it, or because she or he was absent or incapacitated, or because several persons claimed to be entitled to receive the amount due, or because the title to the obligation has been lost. Number 3. Previous notice of the consignation had been given to the person interested in the performance of the obligation. Number 4. The amount due was placed at the disposal of the court. And lastly, after the consignation had been made, the person interested was notified of the action. Note that failure in any of these requirements is enough ground to render a consignation ineffective. Okay, mandatory construction of the codal provisions on consignation. The Supreme Court ruled that the codal provision of the Civil Code dealing with consignation, Articles 1252 to 1261, should be accorded a mandatory construction. So, it states that we do not agree with the question decision. We hold that the essential requisites of a valid consignation must be complied with fully and strictly in accordance with the law. Articles 1256 to 1261, New Civil Code. That these articles must be accorded a mandatory construction is clearly evident and plain from the very language of the codal provisions themselves, which require absolute compliance with the essential requisites therein provided. Substantial compliance is not enough, for that would render only directory construction to the law. The use of the words shall and must, which are imperative, operating to impose a duty which may be enforced, positively indicated that all the essential requisites of a valid consignation must be complied with. The Civil Code articles expressly and explicitly direct what must be essentially done in order that consignation shall be valid and effectual. Likewise, the Supreme Court enumerated the requirements prescribed by law for a valid consignation. One of the given requirements is that after consignation had been made, the person interested was notified thereof. Article 1178 Civil Code. The reason for such requirement was given by the Supreme Court. It stated that there should be notice to the creditor prior and after consignation as required by the Civil Code. The reason for this is obvious, namely to enable the creditor to withdraw the goods or money deposited. Indeed, it would be unjust to make him suffer the risk for any deterioration, depreciation, or loss of such goods or money by reason of lack of knowledge of the consignation. Complaint for consignation. In one case, the Supreme Court held, to wit, the records reveal that Respondent Corporation did not file any formal complaint for consignation but merely deposited the check with the clerk of court. A formal complaint must be commenced with the trial court to provide the proper venue for the determination if there is a valid tender of payment. Rationale for consignation. The rationale for consignation is to avoid the performance of an obligation becoming more onerous to the debtor by reason of causes not imputable to him. Okay, so let's proceed to Article 1257. In order that the consignation of the thing due may release the obligor, it must first be announced to the persons interested in the fulfillment of the obligation. The consignation shall be ineffectual if it is not made strictly in consonance with the provisions which regulate the payment. So accordingly, para ma-release si debtor or si obligor sa iyahang obligation or responsibility, there should be prior notice to persons interested. So, kinsa maning persons interested? So, they are guarantors, mortgagees, or mga solidary debtors and creditors. So, kung walay prior notice gikan ana nila, ang consignation is void or simply not valid. So, sa second paragraph, which is the consignation shall be ineffectual if it is not made strictly in consonance with the provisions which regulate payment. So, it's as simple as ang consignation must also comply with the provisions on payment. So, ang provisions on payment mauna ang rules of payment. Like it should be made in legal tender. Okay, Article 1258. Consignation shall be made by depositing the things due at the disposal of judicial authority, before whom the tender of payment shall be proved in a proper case, and the announcement of the consignation in other cases. The consignation having been made, the interested parties shall also be notified thereof. So, kani nga provision actually just answers the question how consignation is actually made. Accordingly, it shall be made by depositing these things due at the disposal of judicial authority, and then, after, there must be proof the tender had been previously made, and also, there is noticed to the interested persons that consignation will be made, and after the consignation must made. So, rationale for consignation. The rationale for consignation is to avoid the performance of an obligation becoming more onerous to the debtor by reason of causes not imputable to him.
Good day everyone, I am Kenan Tito Libas of BSA 1D, and I am going to continue the discussion of Ms. Lacobtan about the Chapter 4, Extinguishment of Obligation, Subsection 3, Tender of Payment and Consignation. So let's start with Article 1259. So the expenses of consignation, when properly made, shall be charged against the creditor. And dapat lang jud po i-charge ang creditor sa expenses of consignation, labo na kung dili jud full sa debtor. And had the creditor accepted the tender of payment. So if i-accept mga ni sa creditor ang tender of payment, So dili na unta mabot nga naay consignation. Di na ta mabot ngadto. And the general rule is that the creditor will bear the expenses of the consignation because consignation of the obligation had been made because the creditor to whom tender of payment was made refused to accept it without just cause. So, ang gingon ganina, kung wala pag i-refuse ni creditor ang obligation ni debtor, so dili na unta maabot og consignation. Moving on, Article 1260. Once the consignation has been duly made, the debtor may ask the judge to order the cancellation of the obligation. Then there is a question: what is the effect once the consignation has been newly made? Debtor may ask the judge to order cancellation of the obligation so that the running interest will be suspended. Pwede na i-cancel yung obligation niya. But Article 1260 states that before the creditor has accepted the consignation or before a judicial declaration that the consignation has been properly made, the debtor may withdraw the thing or the sum deposited, allowing the obligation to remain in force. In force because iyang gi-withdraw, and it is the right of debtor as a matter of right. Pwede niyang i-withdraw prior to the acceptance of creditor or pwede pod prior sa declaration ng court that the consignation is properly made. That's why he has the right to withdraw the same thing or the same amount of money na iyang gi-deposit. If that's the case, then the creditor will not bear any more about the expenses but the debtor. Although naa siya'y consignation, but the debtor withdraw the thing or the money. However, either the creditor has accepted the consignation or the court has declared it to be proper, hindi na as a matter of right na pwedeng i-withdraw ni debtor ang thing or the amount of money. Pero, pwede niya ma-withdraw, pero dapat nanay consent or authorized by the creditor. Now, how can the creditor prevent the debtor from exercising the right to withdraw the consigned? Simply by just accepting the consignation. Now, how about the consignation was improperly made? What is the effect? The obligation remains because the consignation is not effective as a payment. So, the consignation would produce no effect, same rapod na sa dismissal of case, wala gihapon siya effect ang consignation. So, mo to siya about sa Article 1260. So let's go to Article 1261. If the consignation having been made, the creditor should authorize the debtor to withdraw the thing. He shall lose every preference which he may have over the thing. The co-debtors, guarantors, and sureties shall be released. The consignation having been made, it means that the creditor has accepted the payment or the court has approved the consignation. So at what I have said kanina, dili na as a matter of right ni debtor. So, if pag i-accept ni creditor and ang consignation or give a consent to debtor, na yung mga effects. And first is the obligation remains. Second, the creditor shall lose every preference which he may have over the thing. Then last is the co-debtors, guarantors, and sureties shall be released. So for example, na boy diri as debtor nangutang sa creditor na si girl og 10,000. Then the due date came of obligation. Boy tendered payment to girl, but girl refuses to accept it. So boy made the consignation and asked the girl for the consent or the authorization. Then the girl gave the boy the consent. Then the court declared that the consignation is properly made. So the question is, ang girl pwede pa ba mo-proceed sa guarantors para sa isang 10,000? So the consignation having been made, the creditor should authorize the debtor to withdraw the same. The girl shall lose every preference which she may have over the thing. The co-debtors, guarantors, and sureties shall be released. That is under the Article 1261. So wala na si J. McLean. So that's all for the discussion. Thank you and keep safe.